Hi everyone, my name is Alexander Zalivako, and I'm the founder of From A to Z law firm. One of the areas of our expertise are sanctions, and in a series of presentations called Sanctions 360 Degrees, we will look into major sanctions economic regimes and the way they affect the lives of private individuals and corporations. Thank you very much for watching.
We will consider today an important element of international economic sanctions legal infrastructure, namely blocking statute, and we will do so by way of general historical overview of the concept of a blocking statute as such, and looking more specifically at one of such statutes, being the EU Blocking Statute, putting it into this historical context of blocking statutes developments, as well as paying more specific attention to the elements of the EU blocking statute, as well as considering some practicalities of its application. Blocking statute is not a new concept. But before we consider the historical perspective of blocking statutes, we first need to have a clear view of what a blocking statute is and what the blocking statute purports to achieve. The blocking statute as a legal concept was born to respond to so-called extra-territorial sanctions, or otherwise known as secondary sanctions. The difference between secondary and primary, or territorial and extraterritorial sanctions, is that the extraterritorial or secondary sanctions purport to regulate the behavior of the parties which have no connection, neither the parties as such nor the transactions in which the parties engage, to the national jurisdiction which purports to regulate that behavior. That may sound complex, but in theory it's quite simple. Suppose you have national jurisdiction A, which prohibits for its nationals, for its corporations, to engage in certain types of transactions with individuals from jurisdiction B. There is nothing objectionable in this type of behavior. In principle, jurisdiction A is a sovereign jurisdiction and can regulate the affairs within its own territory in the way it pleases, including to prohibit its nationals to deal with the nationals of jurisdiction B. And this type of regulation is known as primary or territorial sanctions. But suppose that the jurisdiction A would prohibit, in the same way, the relationships between jurisdiction C, which has nothing to do with jurisdiction A, and maybe even friendly to jurisdiction B, so to jurisdiction C with jurisdiction B. This type of economic restrictions have the extraterritorial effect, or secondary sanctions, and certainly we see here the main problem, that jurisdiction A, by this type of regulation, aims to interfere into the economic relationships between two sovereign nations, jurisdiction B and jurisdiction C, which has nothing to do with it, and as I mentioned, in principle can be friendly jurisdictions. So a blocking statute aims to oppose, counteract this type of regulations, and the way the blocking statute would typically do so is by way of prohibiting for its nationals and corporations to comply with the extraterritorial effect of this type of regulations. So my hypothetical example, jurisdiction C would impose a blocking statute prohibiting its nationals and its corporations to comply with the sanctions of the jurisdiction A. Whilst secondary sanctions are now discussed commonly and is one of the hot topics, especially in the context of Western sanctions against Russia, in effect, both secondary sanctions and the attempts to oppose such secondary sanctions have a long historical background and can be traced, for example, as far back as 1948, when the Arab League imposed secondary sanctions against Israel. In which sense? In the sense that not only Arab League attempted to regulate its own trade, its own nationals and its own corporations trading with Israel, which would be an example of primary sanctions, Arab League nations being in principle free to regulate the relationships between its own nationals and its own corporations and third-party nationals in the way they please. But they also attempted to regulate the trade between third country corporations and third country nationals with Israel. And they were doing so in the following way. They created a blacklist of those corporations which continued to trade with Israel, and they prohibited their own corporations to trade with those corporations. And it's a paradox, which may not be that obvious from today's world, that the United States, for example, at the relevant time was the main opponent of this type of behavior on the basis of intervention in its sovereign matters. And for example, the United States at that time imposed a blocking statute, so the statute which aims to oppose, to counteract this type of regulations on the basis that it was extraterritorial, intervening into the sovereign matters of the United States, and the blocking statute prohibited the US corporations to comply with those restrictions of the Arab League. The irony of this example is that certainly in today's world, it is the United States which is primarily using the secondary sanctions as a mechanism to exercise its political power. We saw the first examples of those being in place with the Cuban and Iran regulations, which since their very beginning applied not only to the US incorporated companies, but also to the subsidiaries of those US companies incorporated in third-party jurisdictions, and as a result being the nationals corporations of those states of incorporation. Nevertheless, the sanctions regimes were drafted as such that all restrictions which would apply to the US persons, being the US corporations in my example, would as a general matter equally apply to their subsidiaries incorporated abroad. What started as a limited extraterritorial concept developed into what is today a full-fledged, full-encompassing extraterritorial effect, meaning that the US regulations attempt to restrict the relationships of any person anywhere in the world dealing any type of transactions with the US, for example, as the ends. That trend started with the Iran Sanctions Act and Helms-Burton Act, which imposed a new regime of sanctions against Cuba in 1996. And as a result of those regulations, multiple jurisdictions imposed or developed or paid additional attention to their blocking statutes with a view to protect the national sovereignty. But what were the limited restrictions applicable within those three sanctions program? Because Iran Sanctions Act covered also sanctions with respect to Libya, is now the main trend of the US sanctions regimes, which, although in different scope, but all have the extraterritorial element, meaning that they potentially apply penalties in the form of designating the relevant persons or corporations to the US SDN list to those transactions and to those persons which deal with the sanctioned persons in the way which does not involve the US jurisdiction in any way. Putting the EU Blocking Statute in the context of this historical expose, one would say that it certainly developed in response to the ISA and the Helms-Burton Act. It was developed by way of a council regulation. And in addition to this council regulation, which scope we would consider in more detail going forward, the European Union also raised the relevant points with the WTO, where ultimately the dispute resulted in a compromise between the United States and the European Union when a memorandum of understanding was signed that the US will not impose the secondary sanctions against EU corporations dealing with Cuba. Nevertheless, as we can see, Iran and Libya were out of the scope of that memorandum of understanding, where the secondary sanctions, from the perspective of the United States, remain in place and were applicable fully. It's important to note that the EU Blocking Statute, which was developed in response to those specific two programs, Libya program being of a limited relevance, Iran and Cuba program, works in a way that the extraterritorial effect only of those two specific sanctions regime is to a limited extent addressed in the blocking statute. So it's not a comprehensive blocking statute which would apply to any US sanctions regime with extraterritorial effect, which restricts EU businesses dealing with third countries or exposing them at the risk of being designated themselves in the United States. It had very limited scope in 1996 when the blocking statute was adopted, which was relevant at that time, because at that time, these were the only regimes with the extraterritorial scope of application. But the EU has not developed this statute going forward. The statute remains today in its original form, so it continues to address only those two regimes, despite the fact that, as I mentioned, now secondary sanctions is a part and parcel of almost any US sanctions regime, which are more than 30. In addition to the blocking statute itself, important pieces of EU legislation which assist in understanding the scope of the blocking statute is the EU Commission implementing regulation, which in essence sets out the criteria which Commission uses to grant derogations, even from those limited restrictions which are imposed by the statute. Commission guidance notes, which sets as a relevant background to the statute itself, purposes it wants to achieve. Despite not being a binding legal document, it's a helpful starting point to get to know the functionality of the statute, as well as the case law of the European Court when it considered the application of the EU blocking statute. So what are the key elements of the EU blocking statute? And these are useful because they set the general principles of how these statutes operate also in other jurisdictions. So it's useful to consider this specific legislation, but also to have it as an example of how the general functionality of this instrument works. The starting point is that the statute prohibits enforcement within the European Union of any decision, law, act, which purpose to give extraterritorial effect to those specific regimes listed in the statute. So as I mentioned, it's not a comprehensive piece of law which addresses any type of extraterritorial sanctions, but only of those specific regimes, and even further of those specific normative acts which are listed in annex to the schedule, which, for the avoidance of doubt, are not comprehensive, even for those two regimes, the Cuban and Iran regime, which the statute purports to address. So first of all, the judgments shall not be enforceable in the European Union. From the practical perspective, this provision is devoid of much practical sense, because certainly the United States do not purport to enforce their judgments or decisions or designations within the territory of the European Union directly. They enforce it within the territory of the United States, and its self-enforcement by the private companies or private individuals within the European Union, which causes most of the issues as we would consider going forward. Second point, Article 5 is probably the most critical element of the statute, and this is the main provision which is often pleaded. It in essence prohibits for any EU person to comply with the extraterritorial legislation. So that's a straightforward prohibition, and one might think that that gives sufficient comfort that these extraterritorial restrictions will not be complied within the European Union, as the statute purports to achieve. We would consider going forward the limitations to this initial conclusion. There are many of them. The main is probably that there is no specific penalty for the failure to comply with this prohibition imposed in the statute itself. So it's left to the national authorities to ensure that there are dissuasive and proportionate penalties which ensure compliance. And at the level of national authorities, there is little interest in imposing any of those penalties. So the main operating provision of the statute is not so efficient in real life, but we will discuss this matter going forward. Article 6 permits to recover damages for any person which incurred those damages in connection with the breach of statute. But it's important to note here that the damages are recoverable only against natural legal persons or any entity causing such damages. And in practical sense, is again very limited in its utility, because most of the damages would not be caused by a legal or natural person or other entity, but would be caused by the US public authorities threatening to designate EU businesses to the US as the analyst for failure to comply with secondary sanctions. Certainly, it would be far-fetched to say that an entity in the context of this provision is a terminology wide enough to cover the US public authorities like OFAC, and it would be even a further stretch to say that any EU court would ever try to impose damages on OFAC for designating EU businesses. And the final provision is that the enforcement of this whole structure is ultimately left to the discretion of the member states. There is no enforcement mechanism, no penalties in the EU Blocking Statute as such. So it's all up to the national authorities, which, as I mentioned, have little interest in the efficient implementation of the statute. So we briefly discussed the general limitations for the efficiency of the blocking statute already. One of them is, as we discussed, that the statute covers only specific two regimes, Cuban and Iran regimes, and even within those two regimes, only specific acts which are set out in the annex to the statute. Given that these are extremely comprehensive regimes developed over many years, it is not that complex to find a new piece of legislation in the form of executive order and base the decision, for example, to terminate a contract on the basis of that executive order rather than on those specific items which are listed in the annex. Further, it's important to note that the purpose of the statute is to protect EU business and EU trade. And from that perspective, it seems that limited comfort can be given to sanctioned persons from relying on the statute, because ultimately they are more connected with a third-party jurisdiction rather than the European Union, and accordingly, given that the purpose is actually to protect the European Union, it is highly likely that the courts would be more inclined to give priority to the interests of the EU corporations trying to comply with the secondary sanctions, rather than to the interests of a sanctioned entity relying on the blocking statute to protect the interests. Certainly, there are examples when two EU corporations with no connection with the sanctioned jurisdiction have a dispute. But even in these circumstances, again, national courts and certainly executive have demonstrated very limited interest in the enforcement of the statute. The right to recover damages we already discussed. The reference to natural legal persons or entity seems to exclude the public authorities, which is the main engine for the enforcement of secondary sanctions and the main cause of risk for non-compliance with secondary sanctions. The main penalty is not a claim for damages, it's not civil or criminal proceedings, but it's actually the designation of non-compliant corporations or individuals on the US SDN list with the resultant blocking sanctions coming from such designation. Substantial discretion for the Commission actually to grant exemptions from what is a relatively weak piece of legislation itself further contributes to its inefficiency. We will discuss this separately. And the final point is probably the most critical point. Almost every single bank or financial institution in the European Union will publicly declare its full compliance with Cuban sanctions. These are all regulated entities, so these declarations set up in the general terms and conditions, internal acts, are very familiar for those banking regulators which are supervising those institutions. We have not had of any such regulator raising a concern that this would cause a breach of the EU blocking statute. Now we would focus on the practicalities of the application of the EU blocking statute. And first, it's important to set out those practical examples where the blocking statute is pleaded so that we know the commercial context of the relevant legal arguments. Well, the blocking statute is often pleaded in the circumstances set out in the first bullet, namely the termination of the contract. So a person is designated by the United States as a SDN, and then EU suppliers of goods and services terminate all existing contracts with such a person, being telephone connection contracts, internet connection contracts, financial contracts, lease agreements, all type of contracts, on the basis that if they pursue this type of relationship, then these might expose them to the risk of secondary sanctions. So that's the most common context in which a person then would try to rely on the blocking statute, saying that as a matter of EU law, you shall not comply with those secondary sanctions because that's prohibited under Article 5 of the blocking statute. And by the way, because you terminate the contract under Article 6, in principle, you shall pay to me damages. So that would be one of the most common examples when the blocking statute defense or argument arises in commercial litigation. Another example of a contractual dispute where blocking statute is relevant is an attempt of a counterparty to claim indemnity or compensation for losses or other similar provision set out in a contract due to the risks of penalties or damages been imposed on that party due to secondary US sanctions. And again, a question arises then as whether this type of provision is valid due to its apparent inconsistency with Article 5 of the Blocking Statute, which has a direct effect and shall override any contractual provisions, and which explicitly says that the persons shall not comply with the secondary sanctions. And finally, certainly freeze of assets, where the assets of a sanctioned corporation or individual are blocked due to the risks of any type of penalties, which bases are the US secondary sanctions. And then the persons which assets are blocked attempting to deblock these assets, referring to the blocking statute and Article 5 saying that this type of behavior is unlawful. As to the contractual disputes, bearing in mind all those general limitations which we've just discussed, the European courts have even further restricted the practical utility of the blocking statutes by saying that the termination of the contracts with the sanctioned person is not something which is clearly prohibited by Article 5. It's up for the national authorities to set out the effect which the breach of Article 5 entail, and this effect may not necessarily be the reinstatement of a terminated contract, but maybe, for example, penalties imposed on the party which terminated the contract. So these even further watered down the potential protection coming from the statute. But even in the circumstances when the national law will actually say that the contract needs to be reinstated due to the termination occurring in breach of the EU Blocking Statute, the General Court and the European Court of Justice seem to approve the position that even in those circumstances, national courts shall weigh the interests of the EU person terminating the contract and the person relying on the blocking statute to oppose the termination, and only in the circumstances when the interests of the person opposing termination outweigh the potential economic damage to the new person, they shall reinstate the contract. And this position was taken by the European courts in the circumstances when, in principle, the EU Blocking Statute specifically provides for the opportunity of the EU person to go to the European Commission and to ask a derogation. So one might expect that if this route of derogation has not been explored, there can be no justification for not reinstating the contract terminated in breach of the blocking statute. But this was not the position taken by the European courts, and this makes the utility of this regulation even less useful to the relevant applicants. National courts in their practice seem to be even less interested in the statute itself. For example, in a dispute between a Dutch forwarder and a German-based client, the forwarder, which relied on the indemnity provisions in the contract, managed to get its case approved that these provisions are valid and enforceable, despite the clear contradiction of those potential provisions with the EU Blocking Statute, Article 5 and Article 6. Nevertheless, without going into much detail and explaining how these two can be mutually reconciled, the court mentioned that the risk of US secondary sanctions penalties is evident, and for that reason, the contractual provision shall be enforced. Another important point to take into account is that even the statute itself allows the persons which are bound to comply with it to ask the European Commission for a derogation. And there is a whole number of cases in the European courts when the Clearstream for example, ask for such derogations to block the assets of its clients. And these derogations were granted by the European Commission, and so the assets were blocked, despite the fact that they were blocked specifically for the purpose to comply with the secondary sanctions. An important point here to note is not just that derogations were granted, but that the procedure whereby they're granted is entirely intransparent for the persons which assets are blocked then pursuant to such derogations. There is no right for such a person to be had in front of the Commission in connection with the grant of the derogations. There is no obligation of the Commission to weigh the interests of the depository in this case to comply with the secondary sanctions and the interests of the persons which assets are blocked, potentially indefinitely. Derogations can have retroactive effect, so it's not even relevant if the relevant person which wants to obtain the derogation acted promptly, without delay, immediately upon the imposition of the sanctions. The person can very well wait up until the litigation starts in national courts and then go and apply for a derogation. So in essence, the procedure is not really balanced in a way of trying to consider the interests of both parties to the matter. And certainly any likelihood that this type of authorizations would be successfully then challenged by the person which assets are blocked are very limited. Thank you very much for watching. I trust that you found this presentation useful, and I hope to see you during my next presentations.